remember the name, but it too.
That was,
He was saying, put it to the back, but they came first, so. Did they come before that guy back?
no, they came in the 26th.
They came first?
Second,
Okay, so they.
so they third.
First.
Yeah. The same.
Yeah, the whole of them. So the one case that doesn't have no other enforcement, I'm gonna call for dismissal.
Okay.
And then we'll do all the.
Okay, you got it. You got it. Okay, so I brought 2 copies. Okay.
You gave them the contract.
No, not yet. Give it to them now.
You can pass it.
Hey, good, how are you? Simon. Hey, Mike. Hello. Hey, how are you?
I don't see. He's showing.
He's right here.
There?
No, he's not, he didn't come in yet, so.
By your friend.
Talk about Marie.
No,
Marie.
no, I can't check and be a citizen.
Yeah.
Yeah.
She got approved, but she didn't pay for the fee.
Yeah, so
Which fee did she pay?
The one with the progress report.
This one?
Mm-hmm.
yes.
So she got approved on
This coming,
Yeah.
so approve PNB, so that the permit is under review.
Yes. Actually, she's just waiting for her to pay the fees.
Mhm.
Okay.
That's what she's pending. Once she paid the fee, then the permit will be issued. But he already went to PNC, it's already been reviewed.
And the parking lot hasn't been built, you're waiting for the permit.
For her to pay the fees.
For the permit.
For the permit.
Yes.
Welcome, everyone. I'd like to call to order the Village of Biscayne Park Code Compliance Board meeting. Today is Wednesday, March 12th. It is 6:01 p.m. Please call roll.
Janie Anderson,
Here.
Dale Blanton,
Here.
Rodolfo Barrientos,
Yeah.
Judy Hammerberg,
Here.
Michael Leonard,
Here.
Ashley Brene Green, Doreen C. Grant,
Present.
Rafael Gutierrez,
Present.
Vanessa Cherry present.
Good evening, everyone. This is a meeting of the Visiting Flood Code Compliance Board. The board is authorized pursuant to chapter 14 of the Village's Land Development Code to ensure compliance with the village's code ordinances. The members of the board are citizens and residents of the village of Biscayne Park who volunteer our time and are not paid for our services. The purpose of each hearing is to give any alleged violators the opportunity to test the decision of the code compliance officer, which results in the issuance of a notice of violation, and to determine whether a violation of the village's code has occurred or is occurring. We are not authorized to dismiss violations based on hardship, ignorance, or the fact that others may be guilty of the same violation. These hearings are conducted in a quasi-judicial manner. Our responsibility is to act much like a judge in the court, and that is to hear cases presented by the village's code compliance officer and to give contradictory argument by the alleged violator. We are not authorized to change the code. The village commission is only authorized to enact and revise codes. Conversely, neither the commission nor the village manager have the authority to overrule the findings of the board. Pursuant to chapter 162 of the Florida statutes, orders of the board can only be appealed to the circuit court of Miami-Dade County. We have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code compliance officer's decision, we must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as prescribed. All documentary evidence presented by the parties must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code compliance officer submits a copy for the hearing file. Each party shall have the right to call and take witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination. To impeach any witnesses regardless of which party first called them to testify, and to rebut the evidence against them. If you intend to address the board and haven't signed in, please do so. Also, anyone planning to address the board, I need you to please stand, raise your right hand so you may be sworn in. You're reminded this board is a quasi-judicial board, and please giving false testimony can be penalized. If the proof of
Please raise your right hand. Do you swear or affirm that the testimony you about to give will be the truth, the whole truth, and nothing but the truth?
Second part, I'm sorry, excuse me. Petitions, deletions, changes, anything.
We have two discussions that we put to the end of the meeting.
So other than that, for the agenda is good, no additions, changes, or deletions. We will have the two ordinances as part of the session.
Correct.
We're ready to the first case.
Good evening, Doreen Grant, Code Compliance Manager for the Code Compliance Department. The first 7 cases we will call are for the property located at 739 Northeast 111th Street. They're in section 8 of the agenda, and they're items 8.4, 8.5, 8.6, 8.7, 8.8, and 8.9. We have council present. And 8.10, yes. So.
Yeah.
8.10, yes.
Yes.
They are here to request fine reductions on 7 liens that have been placed on this property for several violations. Before you is contract of sale. This property is up for sale. We have the real estate agent here as well. And we also have the property owner's brother on Zoom from New York. And like I said before you is the contract of sale, which I'd like to enter as evidence tonight. This property is up for sale. They have a buyer. And the buyer intends to demolish this building according to the agent. And they are asking for relief on these liens so that they can go ahead and demolish this building and rebuild the brand new house.
First of all, I really appreciate that we have a copy of the contract. Thank you both, all of you very much for that. If the plan is to hear these each individually, which I believe would be necessary since they are each individually owned, would anybody have an objection if we change the order?
Absolutely not.
What I'd like to do, if there are no objections from the board, is have 8.6 first. 8.5 second. 8.10. 8.4. 8.8. 8.7. And 8.3.
Did you repeat that order?
8.6. 8.5. 8.10. 8.4. 8.8. 8.7. And 8.3.
Great. That's the one, two.
No objections. I don't
have an objection, I just want to see rationale.
Yeah, I will call it at the end.
Well, I understand the fine amount,
And in situations, they're all situations are much different.
somewhat. Okay,
First case.
The first case,
8.6.
8.6, address 739 Northeast 111th Street. It's case number EEN-17-0004. Brett Anthony Frey is the property owner, here to request a fine reduction. This was a violation for discolored walls and a dirty roof. Outstanding.
well, no, I just want to get, so from what, reading over the material, it was they're offering $2,000 for each outstanding case.
Correct.
Questions, comments?
Well, can you give us a breakdown on the amount? on this?
It has all the, yeah, you hear all of them? Yeah. I did.
14,000.
They have to be in this order. I don't know. I'm not serious.
For the 25, and no administrative fee.
$25 project, you find it a hot dollar. Exactly.
I remember.
17,004.
The individual was by himself, and I think Maureen, you said that I believe the time that you guys were working with him because he didn't want to leave his home and all this stuff, and he was working with him.
Yes, we've issued several violations over the years. Sometimes we never got a response from this particular property owner, so we had to request PD to do a welfare check on, I think, 2 or 3 occasions. We came to find out that this individual was not well. He has a severe health hardship and he's also suffering from depression. And we considered all that when we put these cases together. The offer that they're giving on say this particular violation, we are also recommending the same offer, considering the history of what this gentleman has gone through. He was sick, and he was also financially losing He losing the house, he was gonna lose the house because of the health issues, and he was unable to work.
The, brother has, you would identify yourself and your relationship.
I'm the attorney for the seller. Laura Graves is here on behalf, she's the real estate agent. And the brother, Matt Fry, is on Zoom, and he has a designated power of attorney, as a durable family power of attorney, and a real estate specific power of attorney.
Yes,
In order to act on his behalf, he had requested that he might be able to explain better than either Laura or myself about the health and other issues his brother has had in
yes.
terms of taking care of his property. So, Matt, if you're able to, if you could explain to the board, we would appreciate that.
Can you hear us?
Can you hear us, sir?
Oh, good evening. Good evening. Hi, can you hear me? Hello?
We can hear you now. Yeah.
You can hear me? Hi, good evening. My name's Matthew Fry. I'm here as power attorney attorney on behalf of my brother Brett. Due to his failing health and my concern for him, he is unable to attend these sessions tonight. He purchased his house to make it his permanent home. He was a freelance camera operator for the film industry when the industry lost its tax incentives for filming in the state of Florida. It relocated to Georgia. Brett then found himself with minimum or no work. His income became inconsistent and he struggled to make ends meet. During the pandemic, Brett did fall into long-term COVID, and it took a toll on his physical and mental health. This also impacted his ability to work when work became available. While this was happening, his wind insurance premium had increased to $2,000 a month, and this doesn't include his homeowner's insurance, property taxes, mortgage, etc. He also was served multiple citations by the village that I recently found out, and all these financial pressures and increased his stress level, which resulted him in having a stroke along with his depression. You've mentioned before that the park police had done welfare checks from his neighbors, calling his friends, family have been concerned about his family health, and we also did welfare checks. Unfortunately, his doctors still have been unable to get his blood pressure under control. He is seeing doctors on a weekly basis now. He gets confused, forgetful, and seems unaware of the gravity of this situation. I've not mentioned that Brett, due to the amount of fines, I didn't mention the fines to my brother, in fear that he might relapse and send him back into the hospital. Concerned about his health, I recently flew to Florida for a welfare check and concluded that he's no longer capable of living alone, physically, mentally, or financially. This was when when the decision was to sell his home, and I made a listing with Laura Graves, who found a buyer immediately for the property. The house is in contract with Raul Reyes. When the title search came back, I then became aware of all these liens against the property. He's borrowed money from friend and family. I also learned that he's cashed his annuity, his pension, against my advice to pay his.
Mike, we just muted you for a moment. Matt. We muted you for a moment. Okay.
Matt, well, I need to know if he can still hear us, because I want
He
to
can.
tell him why we did that.
Can you hear us?
Yes, I could hear you.
So the only reason I'm asking you, and I'm interrupting, is I think we have heard and we totally get it. And we understand the property's under contract, the important thing is moving forward. So I'm going to kind of pull it back now to the board and Mr. Shedd and Ms. Graves to input, and then we can deal with this first case, how the board sees fit. So if you could bear with us, sir.
Yes, ma'am. Thank you.
So I did not realize we would be going individually case by case, but I will point out that Laura and I have been doing a lot of research, and Ms. Brandt has been very helpful with Laura. And what I noticed when I was doing my own research is that some of the older cases, the liens going back to 2015 and 2021, I couldn't even review the record because there are certain items that are missing from the record. I also noticed that a couple of the items were duplicated, like there's 2 separate liens for the roof, there's 2 separate liens for the painting. And then I know you guys are aware that as far as the law goes, you can only go to a certain level in terms of fines for a certain violation, like what?
If you would,
Okay.
pull it back
Sure.
to the board
Yeah.
for
Any-
discussion. I know
Yeah.
how I feel, but I'd like to hear from everybody else
Sure.
first in terms of the 2,000.
Well. For this, I'd like to go ahead and accept the offer,
We can-
and I would like to move forward on all of them. I took it as a whole to begin with,
Right.
after looking for all of them. And knowing the cases, I think I was present at most all of these,
Sure.
hearings, for this case. I thought it was reasonable, and I was glad to see an offer come in for a decent amount for each and every.
I have to
case.
say, that was my first impression,
So,
that under the circumstances, and again, I thank you for providing that contract, because that just eases certainly my mind, and I think all of us, that, yes, it's all moving forward, and that's what we really all want. So if we want to pull it back, here are all 7 cases. Do we all feel to be comfortably agreeing to the 2,000 per case for a total of 14?
I certainly do, and I wouldn't mind.
Okay,
making a
I'm
motion
good.
for that.
I'll second.
Okay, if you don't mind,
Yeah.
I'd like to make,
Do the formula.
yeah. Like to make a motion to accept, $2,000 for each of the following cases for a total of 14,000. Sure. Then you got me all out of order.
8.6, 8.6.
6.4.
It's time to call the.
Okay, on case number, I've got one. On, case.
I can read the cases into the record for you.
Read them into the record, each one for the 7 cases.
Oh. 7 cases with liens onto the record. Case number 8-12-1673. Case number EEN 17-0004. Case number CEN 23-299. Case number CEN 23-300. Case number CEN 23-301. Case number CEN 23-417. That's all.
Okay. On the previous case, you mentioned, to accept fine reduction of $2,000 per case, total of $15,000. To be paid by. When do y'all close?
Well, we're due to close April 10th.
April
So
10th?
they'll be paid as part of the closing. I'll prepare an affidavit as well, which the buyer will sign, which will tie the buyer into this as well. And the reason I brought Laura, just so you know, is if you guys saw the contract, you know that the buyer is sending his work to the village frequently, and obviously nothing is more important to them to make sure that a good structure is built there, which obviously will help our tax base as well. If he's already doing how many properties in.
He's completed multiple homes and is currently working on several as well.
Right.
You just have to start.
So if I could,
That's what-
April the 15th, in case something.
Yeah.
happens.
What
It's the case, yeah.
Okay,
We should be fine by April 15th.
okay, to be paid in full by April the 15th, or the fines, go back to the, buildings.
Jerry, I believe you second.
I second.
All in favor, we have a motion and a second to accept $2,000 per case for a total of 14 to be paid by April 15th, if not the fines, we revert back to what they previously were. All in favor?
Aye.
Any opposed? Motion passes 5-0. Thank you both.
Thank you very much.
Thank you, sir.
There's one more case I would like to read before you leave.
Thank you.
For the same
Oh,
property.
yes, sure.
It's a new business and it's under 7.1. It's case number CEN 24 2739 for the same property owner. This was a violation for exterior walls, faded and chipped. Similar violations as the old violations, but this was a newer violation. We issued multiple violations because there was no compliance. So after we leaned, the only recourse we could take was issue another violation. I'm asking this board to dismiss this case based on the sale contract that we submitted into the evidence. There will be.
Motion to dismiss in CEN 24-739.
Second.
All in favor?
Aye.
Any opposed? Motion passes 7-0.
Thank you all for your time.
Thank you, both.
Thank you.
Thank you for your time.
Thank you, sir. Good luck.
Next item in old business is 6.1. It's for the property located at 826 Northeast 121st Street. It's case number EEN 22-383 with Jan Roots and his wife Denise. We have counsel present on behalf of the mortgage company. We have counsel present on behalf of the village. We have the building official as a witness. Oh, he could. Let's go ahead.
So we see that it becomes understandable when you see the email from the building official that it was a flat rate agreed to, so Cap would have logically had no reason to formulate hourly breakouts, because whether they went over what they thought they were going or under, there was the flat rate that would be due them. So I did get it. Other comments from the board? Any more from staff?
No.
Well, sir, you've been sworn in.
Yes,
And would your name and your relationship to the property?
yeah, my name is Attorney Caleb Posing. I represent the mortgage servicer who has the mortgage on the property. And just again, want to reiterate what was reiterated back at the hearing on back in December. Again, no information has been provided to my office as far as the detailed breakdown. What is making up of the $10,000 potential lien is being requested based on this property. It was asked for well before that hearing. It was asked for since this hearing was moved to January and then rescheduled again to now to this day, still nothing has been provided that shows us any sort of breakdown of where this amount is coming from. So we would ask that because they have not complied to provide any sort of record to office, as was instructed back in December, that there being certain.
May I be heard on that?
Yes,
Please.
Brad.
That's what I was waiting to hear your permission. That's all right. Good evening, Madam Chair, board members, Brad Weissman, village attorney. I would suggest to the members of the board that council's argument as to why the lien should be dismissed is basically without merit. And the reason why I would say that, and we've got the building official here who put some additional testimony on with regards to the basis for the lien. As the chair, as Madam Chair has correctly pointed out, this was a flat fee. I would suggest that the building official, again, he's present, I believe he's been placed under oath, and I would ask you to hear his testimony. But essentially, he would testify that this was a discounted rate that was provided to the village, that the estimate of what the cost would have been would have exceeded the $10,000 flat fee. Based, and I believe the building official can testify before this board that based on the amount of time, although they didn't keep records as to the actual amount of time they're out, that they worked, but based on the amount of work that the company and the building official and its associates did in this matter, that if they would have charged their rate, that they would have exceeded the average and the bill would have been much higher.
considerably higher, than $10,000. So the building official was present,
If you would, thank you.
probably require, or do you want to just let it out?
I'm sorry.
Do you want me to inquire?
To cross-examine.
Just, yeah, he can explain. All right, you stay there and I'll. Okay, so if you can state your name.
Yeah, there is Fred Martinez, I'm the building official for.
And are you employed directly by the village or you are an outside contractor?
They have an outside contractor to work for, Cap Government, we provide a service for the building department for the building state project.
And did you enter into a written agreement with the village of Biscayne Park? That was executed by the previous manager, again, I guess it was two previous managers. In which you agreed to perform
the mic, right?
the function of preparing this matter. The
That is correct, the company Cap Government, presented an estimate, negotiated with Marius Diaz, the city manager at that time. And agreed on a discount for a flat fee to provide the services. We estimated more time would be needed, a higher cost that are on rate of $110 an hour plus secretaries and copies, etc. But flat fee was agreed upon. How much did you say now? $100 an hour. That's a fee we have this contract. So we estimated the number of hours we need to, and we said to that tomorrow.
If you could tell the board, what was the estimate that you initially presented in there?
I don't know, but I remember it was over $12,000. You have it. We, I think, Cap left it in the invoice. Yes, it was kept in the invoice with a discount given, that's at a flat fee at the bottom.
With regard to the original estimate of time, what we talked about that based upon an hourly rate of $110 an hour plus hourly.
An estimate, yes.
Okay, and then what happened with regard to the village and said, here's my estimate, or did you already discount it to provide that?
No, Mario, if you want to go with the risk of having it be more expensive. So, he's a good negotiator, we put it down. I don't negotiate the contracts with the building company. And, we do it for a lump sum payment of $10,000 with no additional risk for the village.
And you're familiar with the amount of work that was done in this project by Cap, by yourself and other Cap officials, is that correct?
Yes, sir.
And I understand you don't know an exact amount of hours, based on the hours that you did work on this project. Charging your rate of $110 an hour, would that have exceeded the $10,000 flat rate?
I think so.
And let me ask you this, and I think the answer is, the question, based upon, the number of hours of work that's involved in this process. Total staff, was the $10,000 during reasonable amount, or provided to the village?
Yes, our goal is to provide the service. We reach the agreement from the prior.
So essentially, I think that we struggled with back in December, and I think last was that we're looking at a bill, now being determined at $0.02 an hour. You know, so, but I know that there are also arrangements where there are flat fees. So, that's what we struggled with. So I think that now we unwound that and figured that out.
We do have projects where we do go by the hours. And everybody punches in and out, and every time they put time in it, then we can get our report. In this case, if there was no project created for our field, it was only
The property, irrespective of the length of time you fund the actual county, is significant. That's the preparation law to presenting a solid case.
yes, that is right. Thanks for saying that is most of the work is going to be 4% of preparing it. And then the presentation of the case,
actually was, another building official, worked with the company at that time, and he saw that. He presented the case and I was present there at the presentation, I'm not sure you saw it in Zoom. So as building official, we both presented the case, but the preparation is the bulk of the work.
Yeah, I just, well, of course, I got clarity with it. I didn't say a fixed rate. Project.
And for the benefit of the other attorney, I understand it's kind of dropped in your lap. I moved into this village in 1996. This has been an ongoing problem to us since 1996. We dealt with it as a resident when I was a commissioner in this village. We dealt with it as a commissioner. This has been an ongoing property problem that I just tell you how many village hours have gone into trying to get this problem.
But the issue at this point is what, when Lockton is meeting, not asked.
And I am completely empathetic, my client's completely empathetic to this board.
No, but in reality, we're not dealing with the past.
The reality is, what we're dealing with here is this violation, where we were provided no information whatsoever, when requested multiple times, and now at this hearing is now when we find out it's a flat with a witness that we were not told was going to be here, nor were presented with information that was flat. If this was a flat from the beginning, why was that not brought up at the original meeting back in December? Why did we have to push it in and back to January?
But I think at this point, I don't know that that's material in that you now know why there were no hourly rates broken out. Because they agreed whatever amount of time half and half people would have to work, this is what.
But I also think that you have the opportunity to grant.
I understand, but I don't know what work, I don't know, I haven't been able to review anything that you've done or the thing that we've done. All we were provided with $10,000, and that was it. Part of the reason why we were looking for an invoice and breakdown was to see the work that was done, to see, and I just don't have the information to go off, and it doesn't seem like we were provided the opportunity to have do proper discovery to review the information.
That sort of breakdown was not provided because it was not necessary under the flat fee arrangement.
This would have been helpful if they had mentioned that to begin with, and again, where we had said it, we've asked multiple times, and again, they've always provided, we don't have it, we don't have it. Where was the information telling us it was a flat fee, so we could request more information than either? We waited for the last minute here at this hearing now to place it and tell you, the board.
I believe Attorney Vanessa was on the email chain when we provided the email that came from the building official. That's the attorney from your office.
I'm going to stand with what I said on, and
I mean, you have the opportunity to cross examine this witness. I mean, you want to take that opportunity?
You certainly ask our building official any questions you so choose.
not at this time.
Brad or Pedro, would you have anything more to add?
I have nothing further to add other than just the comment that this council was not provided with a breakdown, which one doesn't exist. Hudson can't get that, which we don't have. So. Just
I wouldn't give you an exact date without looking at the emails, but it was a lot of emails back and forth.
And was this in the last 48 hours or 4 days or 4 weeks?
I would say in the last month.
The last one?
Mhm.
Did you were that email?
I was aware that they informed us that work was done, but again, no information was provided, no, they didn't have a breakdown. Again, it was nothing deliberate saying that it was a flat fee or a flat fee agreement provided, to my knowledge, of an email that was sent. But again, I'm here saying that what was asked
From
of,
December.
by this board,
Yeah,
the
that's
breakdown,
what I
and it was.
If no one has any further questions from staff or from the board, no further comments from our building official or our attorney, I'd like to sign a motion.
I'd like to make a motion on case number. EN-22-383, direct the village, move forward with the consent lien for $10,000 plus the applicable, filing fees.
I'll second
I have a motion and a second, all in favor? Aye.
Aye.
Any opposed? Motion passes by zero.
Next item on the agenda. Under eight, section 8, and it's 8.1 and 8.2. And 8.3, fine reduction. This is for the property located at 11140 Griffin Boulevard. Case number EEN 19-1556, case number EEN 19-1636, and case number EEN 22-0579. These violations were for materials that were left on the property, a dilapidated fence, and failure to maintain a gate. However, the current owner was not the violator. This property was sold at an auction, and the liens that were on the property prior to them purchasing the property survived the auction. So they are now responsible for the liens that are on the property, and they are asking for reduction.
Well, has the issue been resolved?
The issue has been resolved. The property, the house was demolished. It's empty lot right now.
So technically, they're completely in compliance.
They are in compliance. That's how it is. Yes, they are very old liens, and they amount to 341,000, I believe, in total.
339 change, or 772 and 120.
Right. One of the cases only has $100 on it, and I would recommend that $100 is not considered. They could pay the $100. I believe it shouldn't be considered as a reduction. Even though he paid the $50, yeah, it's for $122, and it's which case?
Is this a vacancy for women?
There's no house.
Is this the one next to the new?
Correct. Yes.
Yeah, this is the one for the gate.
Do we know how much an administrative fees were on there?
Administrative fees, I believe these liens are, one of them is very old, so it was $25.
Okay, in this case, probably we should settle in on one at a
Yeah.
time and not go down to four. If we could do the 339.
The one with the highest lien,
The most significant.
yes.
Because we know the amount of days it took, well, never mind, forget that question, if the money is the highest, so we done it. It's gonna have to be on the cases to compliance, but.
Well, this is not the property owner, when the property was in violation,
It's not relevant anyway.
Correct. they bought the property at the courthouse.
Right, I'd like to know what cases we're looking at. Only 339 is.
Which one is 339?
Okay.
Hold this.
So this was violation of construction work.
What's the hundreds?
And, oh,
Yes, what-
the property, the house has been demolished for quite a while, hasn't it?
124. Is the one for the 15.
I will. Is this better? Okay, well, sorry. My name is Robin Giovanni, and I have the power of attorney in my hand. I thought you were going to report this. Basically, we bought the property in the courthouse steps. And after it was sold, there was a surplus of funds, and then the attorney that we hired, they contacted the city so that the city could get the surplus, but then I think Doreen told me that there were some legal issues.
Yes,
So the Biscayne Park couldn't claim the surplus of funds. So now we are coming to this hearing, speaking to this hearing, and I want to point out the fact that we plan to build a property on the lot, and I brought the renderings with me from the architect. Should I hand it to you? So
Can
basically.
you leave them to us?
Yeah, I can, that's fine. So this is like what it will look like, the front and the back and the floor plans. And so we're hoping to resolve the lease so that when we go to build, that we don't have issues. And we're offering $500 for each case, so that's $1,500.
And what was the surplus that you were offering?
And what you said?
You said there was a surplus you were offering the village?
Oh, I wasn't offering, so I think to my knowledge, there was like 300,000 surplus.
Yes, when sorry not to interrupt you, when the property was sold by the county, there was a surplus of $300,000 that was left in the coffers because all the county needed was the taxes that were owing. So, or whatever else. Now, in the hierarchy of liens, we were very much on the bottom. So I'm not sure there was a mortgage, but there were other liens that preceded our liens. So that money went to paying for those liens. When our lease pendants was filed, I believe we were already late. I did consult with the village attorney on this, and we were late in filing our lease pendants, so we could not claim the 300,000 or some of it. We were not able to.
Well, in looking at the fine reduction case we just heard, going with this first case in front of us, I'll be honest, I'm not comfortable with a $500 offer.
Well. I mean, what is the house? Does anybody know when this when the house was
Demolished.
demolished?
I believe the previous owner bought this house. It used to be the mayor's house.
Right.
They bought the property and demolished it. It was a few years that.
It's been about 10 years, eight
Correct.
to 10 years.
It's been about that, yeah, that amount of time.
Yeah,
So they demolished the property with the intention of rebuilding.
Right.
But I believe they ran into some financial issues and were not able to.
right. And that's what I thought. I just wanted to make sure I had the right property.
That's it.
And it
That's
was
the
about,
one.
yeah, 8 or 10 years ago, demolished, I believe. So. So, but these fines accrued up until when? I see there, or there's already a lien, so they'd already been placed.
Correct.
Do we know when the liens were placed?
Yep.
Yes.
The first one was August of 2024.
August of 2024.
Right.
So. And fines had been accruing up to that point
Correct.
for a house that was demolished.
Correct. Now, the violations were for trash that was left on the property, was debris. I believe from the demolition, some of it, and then there was a security fence, which was a chain link fence that had fallen and the gate was unsecure. So these were minor violations that could have been corrected easily, but because this property owner.
The debris in question had to do with the demolition.
That's correct. And then the property owner just fell off and just let the property go.
Right.
Did you have any recommendations during based on the amount of time that you had to put into this?
Yes, considering that they were not the violators, they bought the property with the violations, which we will still hold them accountable for. I would recommend a total of 4,000, which is 2,000 for each for each lien. The other lien for $100, I believe they could just pay the $100. They don't have to reduce that.
I would be comfortable with that. But 4,000 on these two.
No.
4,000
No, 2,000.
is the total
2,000
for each lien.
For what we have before.
Oh, I'm so sorry. Hold on. The one lien was $750, so we couldn't do.
Yeah.
So we'll do 2,000 on the one lien for 300,000 and the 500 for the 750 lien.
I would rather leave the 7 and change alone, just like the one.
With the
Because
100.
that 7 encompasses a violation fine and an admin fine, and we really should not be reducing either of those two. So I'm comfortable with 2,000 on the $339,000 one, but the other two, which are
750 and 100.
750 and you're 120 being changed, I'd like those left alone.
Would you consider 1,000? Would you consider 1,000? Because you have to put a lot of money into the plans and to start building.
I won't, it's the only thing,
Well,
I won't, I'm comfortable with what sounds like the
Speaker.
Well, these liens that they, when they were selling on the playoff staff, would these liens have been known at that time?
Yes, they were known, and that's how the attorney was able to contact us. They saw the liens in the public records and contacted.
So they would have bought the property knowing that there was.
Correct. And the reason they were very adamant about letting us know was because of the 300,000 surplus that was there. They were not aware that there were other liens that were superseded, I'm sorry, these code compliance liens. So the other liens were considered first and they were paid and there was nothing left for us. So we were
Well, I
sure.
guess from your standpoint, it'd be reasonable to assume that if they're contacting you with a $300,000 surplus and there's over $300,000 in liens, that they were trying to get that dealt with the money that they had at the time, but then they found out that there's other bills in front, right?
Right. That was the county. The county had the money, not them.
Right.
Mhm.
Okay, but here we are today. How many years later,
Right. Stuff with the lien.
you're telling us that 2000, you feel comfortable with it from the time you had to put into it.
Is anyone ready to make a motion?
well, you don't make, this is a fine reduction. You either, an offer has been done for 1,500 for all 3 cases.
Motion.
I would make a motion to not accept the $1,500 covering cases EEN 19-1556, 1636, and EEN 220579. My motion will be to not accept the $500.
I'll second.
All in favor?
Aye.
Any opposed? Motion carries 5-0.
What happened now?
So
They'll do another motion.
you're welcome to make another offer.
Like right now?
Yes, please.
Oh, okay, so how about the one that you gave me right before, so 2,000 for the 300,000 lien, and then the other two, you just leave it as it is. Like, how about that?
I mean, I'm comfortable with that.
We pass them on. That means
Yeah, so if there's no other discussion, I'd like to make a motion on case number EN-22-383, CEN-24-64-697, and those are all numbers.
I can read those numbers into the record for you.
I have the-
The total for the
Okay,
liens.
oh, the totals.
just reading for the record only.
Okay.
Yeah.
Case number EEN 19-1556.
300,000.
The offer of $2,000 in EEN 191636, the fine of $772.50 for liens, and in EEN 220579, the fine of
The guy, 744. This one?
122 for the remaining.
So that all. So for a total of $2,872.50. To be paid by April the 15th. Okay, if not, the fines resort back to the original.
I'll second.
Have a motion in a second, all in favor?
Aye.
Motion passes 5-0. Thank you.
Next item.
Here, 2030.
Yeah, $2,872.50.
What's the payment date? Pay by 15.
That would work.
The next item is 7.2, and it's for the address 744 Northeast 113th Street. It's for the case number CEC 25-0069 for Mark Newman Salinero and Alejandra Michelle Salinero. In this case, we are asking for an order of enforcement as a finding of fact for a violation that has already been paid, the double fee permit fine. This particular property owner was found in violation of section 16.14.1. They had permits for a roof for their property. Permits with the work was going fine. We had permits in the system and everything. But when one of the inspectors went to the property, they found that there was extra work that was done that was not on the plans. And that's how they were charged the double fee permits. I wanted to let the board know that he has complied and paid the double fees for the other permit. However, this is a precedent case because during the process of investigating this case, we found that his roofer, this wasn't the property owner, the roofer or someone who was representing the roofer had used a fake stamp to pass the plan so they could move to another stage when the plans hadn't really gone through the right process in the building department. They took an old stamp, forged it, and put it on the plans. Now the police department is handling this part of the case. I would need to get a follow-up status from them on where they are with this case. It's not, the owner will not be held responsible for that because the roofer is responsible for maintaining his license and what goes with his license. But I wanted to put it on the record that sometimes contractors do this stuff and property owners have to be looking out for what they are doing. Back to the case, I would like this board to put on the record a finding of fact for the violation that happened.
So part of the roof was permitted
It was permitted.
and this was additional.
Mhm.
Yeah, if I could,
If you would like to verify yourself, about the relationship to the property.
Yeah, no problem. Mark Salinero, the property owner at 744 Northeast 113th Street. So just to be, just so I could be clear about this is strictly for the carport, right? So
It's for the carport.
Okay.
We have a stop order on the actual roof until the case is resolved with PD. They may not allow you to go on with that roof. They need to resolve the issue with the building, with
Yeah,
the
well,
roofing contractor.
Okay, well, I guess I'll keep that separate because
Absolutely.
tonight's the carport. I guess my position is the roof permit was issued.
Mhm.
That carport is continuous with the home. It's not a separate structure, right? So this is the first time I've replaced the roof on a house. My wife and I bought the house in 2020. It's my understanding that it was contemplated in the original permit to repair the carport, right? Part of it was damaged, so I knew that there was gonna be some repair. They began replacing the roof and they found that they needed to replace it, right? And when I say replace, I mean the tongue and groove, decking and the trusses that were on, right? So it was replaced in the same exact manner that it was previously. And my position, I didn't know that there needed to be an additional permit pulled for, yeah.
Your permit is issued based on what your plans show. And if the plans did not show a new roof in this particular area, that's what you can work out from.
Well, the roof was over the carport permitted to be done. It's how roof over the carport. This was, if you were to step into the carport and look up, this portion here, yeah, so I'm just putting the record, I didn't know about it, so, you know, to the extent that the board considers that, I'm not sure. But, you know, the permit, I paid for the roof was around $1,200 for the roof itself, I don't know what the permit's gonna cost for the structure portion of it. They've had to retain an architect and engineer to now draw the plans for it, so there has been additional costs, so we need to be all aware of that as well.
Doreen, you're saying that, the original permit contemplated the carport.
Well, I meant the permit, I meant the permit valuation, in terms of what the roofer put on there. I knew that there was gonna have to be a repair to a portion of it because some of the tongue and groove decking had been deteriorated, so, you know, at the start it was, okay, this is what's gonna be the tall roof and repair to a portion of the carport, but then it turned into the cricket, there was more damage, and so like I said, we're gonna replace the entirety of the guts, I guess you could say, of the
So
carport.
at that point, they would have needed to update the plans, update.
Correct.
everything, and go back in front of P and Z because of the repair, of a brand new roof, because it's very different, obviously, from the repair.
What is the shingle, was the roof covering the same, the carport as the rest of the
Yeah,
house?
yeah,
It's
it
the
was a
same.
shingle roof and now it's tile roof, to be
Yeah.
tile,
Including the
I-
carport?
including the carport, yeah.
So this particular violation was brought to us by a building inspector. So the building inspector that went to the house looked at that work and said, this work is not on the plan, and he could not put his signature on approving that because it wasn't on the plan and he wasn't comfortable doing it. We actually went out with PD and the building official. The building official confirmed that a roof like that, even though it's supposed to be like a ceiling, it needs certain type of straps, it needs certain type of assurance for them to sign it off and say it's safe. As a building official, he could not sign it off without being approved by
Yeah,
planning and design.
Even when
So-
they're not working, we didn't look
Right.
at this.
So he did, correct. So he did comply. He did come to the village and he worked with us. He worked with the building department. He paid the double fines. However, I wanted this to be on the record
Sure.
and for a finding of fact, because it's a big problem for contractors doing work outside of their permits. And it's very difficult for us to track it and very difficult for us to know what's going on if no one brings it to our attention.
I was gonna say, just for clarity, had this just been one truss maybe replaced or
That
some of the
would,
ladding
correct.
replaced.
But it
because
was an
that's-
entire roof.
That's common with replacement of a roof.
You're right.
But the entire thing from the pictures I'm looking at was
Yeah.
replaced. Okay.
You cooperating with the police? They actually be part of that?
they took my license the day that they came, so I mean, they have my information, but I went to planning and design, they approved to go forward, so now buildings pending, everything else, so.
And what they sold for?
So they do not hold they would not hold him accountable or responsible for what the roofing contractor did. As a contractor, he has a license and he knows what the rules are. So he went outside of his professional rules and he will be held accountable criminally for what happened.
But unfortunately, ultimately, it's the homeowner's responsibility. Yes, this is South Florida, and you know what we run up against with certain contractors, but like until everybody comes in front of us, it's still on the homeowner.
Yeah, they have to watch what their contractors is doing. And as much as we trust them as professionals, but as a property owner, ultimately, your roof is not going anywhere right now. There's a stop order, stop work order.
So basically,
So-
all what for us is commencing work without a permit.
Correct.
All right, or public. So, like. Motion case number CEC 25 0069, that a violation did occur and assess a fine of $250.
So there's a fine on top of the double permit?
Yes.
Oh, no.
Wait, and assess no administrative cost, given that there was.
The manager.
Is it here?
I'll second that.
Hopefully, Lord, no.
Otherwise.
Who is it? Like,
Oh,
Who's this?
I didn't know that there was a $50 fee Came for the, okay.
I never received a need that.
I'll do it twice before. Twice before, okay.
So could we vote to the plan?
Later.
I like you to, fifty, waive the admin fee.
Oh, wait.
All in favor?
Aye.
No, motion passes 5-0.
And then, what time today, or what's the deadline to? I can go tomorrow, pay, I just wanna know what the time is.
To be paid by, March.
Don't worry, I'm
March the 30th.
Don't worry, I'm gonna go tomorrow, just pay the check to the village hall.
Yes.
Okay. Okay, all right,
Yeah,
thank you.
so I have a lot of-
Yeah, I appreciate it.
It's expensive. Yes. Next item, 6.6, for the address 11501 Northeast 11th Place. This is for the case number CEN 22-115. It's a real R Bar and his wife Sally. We're bringing this case for a progress report. They were found in violation of chapter 5.6 off-street parking. Their driveway did not meet the design standards set forth in this section. This is a homestead, and Sally is here. We spoke before, and this was my note, Sally, that you needed to speak with your husband before you made a decision to move forward with this. So you can go ahead and explain to the board when they're ready for you.
We are looking at finance date, well, this case has been open since December of 2022.
22.
We heard it first last January, we gave a compliance date of March 24th. Well, and that would have meant having the permit,
Correct.
that would have constituted compliance. Where are we a year later?
So they did apply for the permit in time, in compliance to that order. This order had no fines on it. They went ahead and applied, and nothing has happened since. That permit hasn't moved. It's still on application stage.
But the order does have a $250 daily fine if not in compliance by the 21st of March. Compliance, and we always make that very clear,
Correct.
is having the permit.
And I had explained this to Sally. This order would have to be amended in order to add an administrative fee and a violation fine, because applying for the permit is not compliance. You needed to go through with the permit and do the driveway. So none of that has happened. So I'm asking the board to amend the order of enforcement.
Or if you would identify yourself in your relationship to property.
Okay, Sally Bard, my partner in the property, owns it also.
We'd like to know what's going
Right,
on.
Okay.
We're
I'll say something. We applied for the permit, and I got something back saying, this isn't right, you have to do this with the permit. The permit for a resident is a very cumbersome process. Now, I went to, okay, I'm gonna stop here. So, I think at that point, it was difficult for me to continue the process, because it's a little difficult to get a permit. Because we were gonna do the work, we weren't gonna hire a contractor, we were gonna do the work ourselves. So everything on the permit points to a contractor. And then, I guess unfortunately, too much time went by and nothing was done, and last year we had quite a medical emergency, so I apologize that I dropped the ball. But I went to planning and zoning on Monday night, because we actually have questions also. The thing is, like, we didn't feel like we needed a new driveway, because we have a driveway, it's
This
just.
one, right?
We have to stop
Okay.
right there for a moment.
Okay.
We went through all this last January. You agreed to go to P and Z very quickly back last January, which is when you were not assessed a violation fine nor an admin fine. There were daily fines built in the fine. But whether or not each of us as individuals feel we need something, if in fact the village's laws and ordinances says we need to do that, we either comply or we end up in a fine situation, which is avoidable if we work with the village, and the village made every effort to work with you. You remember that meeting, I'm sure.
I did remember that meeting, and it was when my compliance date became due was when I was called away for 3 hours away for a medical emergency with my grandson, he has brain tumor. So all of last year, I was pregnant. So, and I know it's not an excuse. I know it's not. And I'm trying to fix it now.
What came out of your meeting with James and Monday? If you wouldn't mind sharing that with us.
Okay, so, look, they worked with me and said to get the permit to bring our driveway up to code compliance. This was Monday night, so, like, maybe hopefully by tomorrow, Friday or Monday, going to the village for work. Again, getting online and getting someone to help me. To pull the permit, so we can do that.
Is there someone in the office who, and I don't know procedures, so forgive me if I'm saying something wrong, tell me quickly. Is there someone in the office, do we have the capability of guiding folks through the process? I mean, at this point, we want to see the property owner get the compliance.
Absolutely.
But
Can I say something about someone in the office? Because in planning and design the other night, I asked if somebody could help me with the, clerk that is at that meeting and said, no, she wasn't allowed to help.
okay. That's
So
what I asked, but I said, if I'm wrong, tell me.
Linda has helped in the past with people who have computer issues.
So it depends on what kind of help she needs. What would you like help with, Sally?
Help pulling the permit because and this is another thing that I have been communicating, you know.
Right.
We've been communicating.
We have been talking.
And
I do have a concern is how far the help goes, because it is critical that everybody be autonomous. If the village gets too involved, there's a burden that falls back on them. We each as homeowners face the same thing, Sally. We've had to apply for multiple permits and Bob's had to win his way through the system. We have that responsibility. Staff can give us some level of guidance, but it's not on them.
And that, I mean, I totally get, because I know the village hall is very busy. I know they're busy every day. And, so I got the number of somebody that said they would help me. It's a person that helps.
This question is basically for the village. Isn't there a packet that the homeowner
Yes.
can come and get?
Yes.
Because I noticed, I came over there the other day for a neighbor of mine because the permit hadn't moved forward. And it was because he had not completed the notarized permit application, a number of different things he had to. I was given the the documents
Yeah.
that, pamphlet that I needed to help him fill out. So there's a packet there.
Mhm.
You go by the village, so they can assist you with, because I'm gonna see at the time, there was 1, 2, 3, 4 items that you needed to complete.
And this was back in March of last year, that's the last communication I can see.
Yeah, she had started the process. There was a message from the building clerk.
Mhm.
All you needed to do was those 4 things, 5 things she was asking you to do. If you had brought those, that information up to date, your permit would have moved up. So that's what you need to do. Come back to the office, talk to the building clerk, and she'll help you move forward.
Okay, because she's.
So
No.
That's good.
It's like this, giving you a packet.
Oh, okay.
Actually, they're on the outside of, as you walk in, they're on the outside of the thing, I think it's read from the bottom. So that would be, because it sounds like you're looking for assistance with with the
Putting in
dimensions,
the.
which
Mhm.
the village, I don't think will be in a place
Yeah.
to assist you with that.
Okay, well, I think that we're all gonna be okay with the dimensions, but it's just, permit itself seemed very
Complicated?
complicated, like for contractors, which I get it, because there's no many contractors here, but, so I must be the biggest one in the world, but I'm come back and try.
Yeah, come back and we'll see what's missing. Okay,
Yeah, because we want to get this over with. We're,
You do have a daily fine line, so
I guess that,
Thanks, sir.
I wasn't aware of that, but.
Can we confirm?
so the way this order was issued, and I went back to read the order. I know it says if she doesn't comply, but by her applying for the permit, there was an implication that she has complied, and this is why I'm asking for this order to be amended.
We do have one.
Correct.
My. Okay, case number CBN 22-115, a violation has occurred. It says a $250 violation fine, a $250 admin fee. Gives the property owner until May 23rd to come into compliance by doing the permit, if not a $250 daily fine.
I'll second.
So this is an amended
Motion
order.
and a second, all in favor? Aye.
Aye.
Any opposed? Motion passes 5-0.
Okay, so. Okay, so right now, we owe. Approximately 500.
500.
So we owe 500, 2 fines.
And you can get that permit by the 21st or
21st of May.
23rd, I'm sorry.
So 23rd of May 23rd.
April, I'm talking all over myself.
Okay.
Okay, it goes to the P&Z meeting.
Okay. April 23rd, and then.
March.
I need to do this other advice, and then I'll be in compliance.
Did you say May or April? April?
I said May, I was just saying April.
You said May. So.
Well, that's, I am going to the motion, because see when the meeting date is.
April the 22nd and 2nd, that's a proposed date.
But if I said my person. Yeah. So I said, what is it?
Well, no, that's a month and a half, right? Day is well.
The 23rd, April 23rd, still could work.
So there would be 2 meetings between now and then.
Our problem is 7 April 21st.
Okay. You gotta be done with that.
April. I meant to say April, April 23rd.
Need to change that.
I'm sorry.
That we need to change the motion.
Yeah, I'm amending my motion to April 21st.
I'll second that.
April
All in
23rd?
favor?
Aye.
April 23rd.
Thank you.
Who is that?
Motion passes.
December 7th.
Second, to two.
Motion passes.
For one?
You voted no? Okay. The motion passes 4-1. Then we should continue the meeting. Then on that is one on the agenda.
Yeah, so I think it's much like really done something point.
This one?
And then
Oh, this is he had sent from the time. It's requesting. How much time?
Yes, he said, make it available. But if I have
Next item, 7.7, for the address 11133 Griffin Boulevard, case number CEC 24-0086, for Modesto Molina and his wife Sarah Crute. We're asking for an order of enforcement They have been found to be in violation of chapter 5.6.7 off-street parking. The existing parking surface does not meet the standards. They do not have a driveway
60 days.
approach. The property owner is here and he is asking for a continuance for 60 days.
What's the agenda?
7.7. Are you Modesto?
Just a moment. Okay, he's asking for a continuance until
60 days.
we know why. Yes, I would identify yourself in a relationship to the property.
I'm Modesto Molina, and I'm the property owner of 11133 Freedom Boulevard. Also my wife is the owner.
So I'm gonna move to.
We are West Redwood, I do have a contractor that I work with, and he's basically backed up for a few months. So that's why we went. So it will be done. Because I know I'm gonna get it. Is already a permit? Is there already a permit? No, he hasn't, I have to, I'm probably gonna have to get the application, say, so we can do that. I wouldn't say he's backed up. Well, he's a contractor, and I like to work with him because I know he's good.
If we agree on an extension, I'd be a little more comfortable with 30 days and ask you to be back to the report. 60 days is already a long time if he's that backed up. If he's not even started the permanent process, remember, sir, to come into compliance, you just can't hold the permit. If your contractor cannot begin work immediately, you have, I believe, 6 months on permits to get the work done. You don't have to get the permit. I was not comfortable with this game.
Well, I wasn't aware that you're trying to finalize the job, okay, so I'm not an expert in this. So that's what I'm here to say, I will get it done. And when I meant 2 months, I mean, completing the whole job in 2 months.
We just want to get the ball rolling.
Yeah, I can get the ball on the floor.
Because things can happen, it's slow down the job.
Yeah, I also had a few technical questions regarding the driveway, because it's a 1940s house, and he already has a driveway that was a lot of grandfather, which,
Yeah.
I wanted to keep it, I had a few questions, and I think last.
The design. I would have no problem tabling this for April's meeting if you want to go back with a progress report.
Absolutely.
And then we can kind of go from there. Board input.
Meanwhile, reach out with the village about,
I'm on board, I wanna get it done, I just, I thought the 2 months to finalize the whole project. You know what I mean? I mean, no, it was just.
Yeah,
apply.
no, I'm.
I can apply for
No,
it.
you don't have to have a drive free.
That's what I,
But
If
for
there's no further
questions,
questions, I'd like to make a motion. Case number CEC 24-0086, that we table until, April's meeting.
I'll second, all in favor? Aye, any opposed? We will see you on April, sir.
and when your questions can go to the planning and design board, they're the people who answer that, and get.
it's not in the village,
They have meetings at night as well.
okay. And where are the meeting folks, when would I know the meeting?
You have to apply. You have to apply
Oh, yeah.
to, yeah, so you can come into Village Hall and we'll help you.
Come and get all the questions answered,
Sure.
and I'll take an application. to get
Yes, sir.
back.
Okay,
All right, thank you, guys.
Bye.
Well,
I would like to respectfully ask the board to move to item 10 of the agenda. Village attorney is here and we would like to bring for discussion ordinance. There is no number for the ordinance, but it is about mitigation and settlement of outstanding liens by the code compliance board.
Thank you.
We're giving the-
hanging in.
Evening again. So just to give you an update, there's the question came up as to whether or not this board has the authority to mitigate liens. And I understand that historically you all have been mitigating these on the board. There is case law and attorney general opinions that basically came out, which if you look at the statute that authorizes municipalities to
new code enforcement and impose liens, result in unpaid fines. The liens themselves, by statute, basically ignore the benefit of the local governing body. That's what the statute says. The local governing body, of course, of the village is the village commission. So what the courts and the attorney general have opined is that it is solely within the discretion of the local governing body to either settle, modify, or reduce liens. However, the local governing body has the authority to delegate that authority to another party, either a private entity or the board, such as yourselves. When you look at your code, there's a mention of liens in the reduction section, but it's only in the title. So when you look at the body of the code, when it talks about the guidelines and the authority of the board to mitigate liens, it only speaks of fines and not liens. So in order to, just as a cleanup, so that it's clear that this board does have the authority to mitigate liens, we are proposing this ordinance that's before you. And essentially what it does is it delegates, it specifically delegates, it's a delegation by the commission to this board to mitigate liens and to settle liens. And it also sets up some additional criteria. So you have your initial criteria that's already in your code that you use when you're entertaining fine reduction requests. And then there were, I think there was two other, I don't have the ordinance in front of me, I didn't know I was going to talk. So there are two other criterias that would also be for your consideration among whatever else you want to consider, which essentially would be whether the property is free from any outstanding debts, including taxes due to the village, and whether any other properties owned by have any active code enforcement cases. So that would just be something for your consideration when you're determining whether or not you would agree to modify or reduce something.
Is this, okay, so all the underlying is all the new stuff.
Yes, I'm sorry. So anything struck through is what we would propose to remove. Anything underlined is what we would propose to add.
So one of the things that we have here is that that number 2 is that the hearing won't be de novo, correct? So
It shouldn't be, but
what are we relying upon? The record that's before us?
you would be relying on the record that's before you, as well as whatever hardship or whatever settlement offer that the property owner or representing the property owner bring forward. The intent of that the record will not be de novo, and I can clean that up because I think I know what you're talking about. Is whether it's not de novo to the extent of whether or not you shouldn't be entertaining whether or not violations exist.
Oh,
So a property owner should not be coming to you and saying, hey,
I didn't do it.
I didn't do it, my property was never in violation, therefore I shouldn't have a liens in the first place. That's already been decided, that's, and I can clean that.
yeah, I think that would be good because we encounter that a lot.
No, I can definitely clean
If you think about it, I swear Gary, when he was chair, used to remind everyone of that before fine reduction.
He did, we used to read out this little thing.
Yeah.
I pull it out each time that we have fine reductions, and basically it's 9 little items, that basically same criteria for a fine reduction.
It's a good practice because it'll limit the conversation.
Right.
We never get notice.
But that's
in taxes or.
No, that we don't, the only thing we do know is, because sometimes they're doing the same sheet of totals, is that there are fee for service things and we don't touch those. That's about the only thing we ever know.
It's essentially a consideration, so it's not.
Yeah, it's not.
In other words, you're not dealing with whether or not
Right.
there's taxes or fees that are owed, but the
Or
question
something
is,
we can consider, but I don't know that we necessarily would, but the fact that we're not retrying the case.
Right.
I need to remember to say that each time the hearing is it.
but to your question, it would be a consideration. So if somebody has outstanding fines or some type of other outstanding debt to the village as it relates to the property that's unpaid, is when you measure the equities of their request, is that a situation where you would want to mitigate? I mean, you still could, if you look, those guidelines are just criteria that you may follow, or that you shall follow. You shall consider them, what way you give those factors is up to you, it's.
Because I mean, I've only been on this board for what, a year and a half or so. And I don't recall ever being told in taxes.
Well, I don't know that it's ever been an issue, so it would be a consideration, so staff could come forward and that something, if they're aware.
Other
that
times on the property.
Yeah, it's just part of
Right,
it.
and my suggestion would be, now, if that's, once that's codified, and that's one of the items or criteria for you to consider. Staff could have that information for you so that you would be able to consider it and give it whatever due weight you all decide.
Thank you. I really appreciate you paying it. Did you want to quickly go over the paint?
I can if you want.
So, okay, with everybody, we also have the paint permit change, which doesn't.
That's one's very, pretty simple.
Strongly affect us, but it's still all part of us, so just a quick overview if you don't mind.
Sure, so the way the village's exterior painting ordinance reads is it requires a property owner to seek a permit, which is ultimately approved through the planning and design review board. There is a statute, please don't ask me to quote the statute on top of my head, but there is a specific statute that states that a municipality cannot impose or not require a permit for exterior painting of residence.
166.
I'm sorry?
It's 166 of the Florida statute.
I know it's 166, but I don't remember. So essentially what we're doing is we're proposing that ordinance be amended to change it from a permit process to just an application of a building permit. So processes will not necessarily change, it's more semantics and wording, so that it can be contested and said if the ordinance is violation, say. And that will both of those ordinances that we just talked about will be for the planning design. But the local planning agency, for sure, planning development code requires them to review it, it's not any comment as it would.
The fence.
Yeah, we can clarify.
They didn't go through the thing.
No, no,
So we, I think that fence permit expired.
Mr. Manager, thank you for us being included on those ordinances, much appreciated.
Next item, 6.2. Under old business. Is for the property located at 915 Northeast 118th Street. Case number CEN 24-697. I'm gonna try and pronounce this name, Queen Zhang Gregory and Campbell White. We were coming for an intent to lien. However, the property owner has paid the fine and is in compliance on that part. However, we will ask this board to amend this order because they applied for a permit in 2024 and they haven't gone anywhere with this permit. The application was put in and nothing was done. Permit's still open and there has been no progress. And while we are amending these orders, we will ask the board that in future, when issuing these kind of orders, compliance should be not just applying for the permit, compliance should be considered when they have complied, install the fence and find out the permit. We can keep these cases open and then comply these cases once they have finished the work. Because what has happened with a lot of cases, we went back and looked at the cases that came before the board with orders that had $250. They're good because they applied for a permit and they haven't done a thing with these permits. Some of them are 2 years old.
You only have to drive around, and
Yes.
several, but, and I told, because I see how people are gaming the system.
Yeah.
You know, we say, as long as you have your permit, you're good.
As long as you apply.
How long is the permit good for?
6 months. So some of them
As soon as that
expire.
expires,
Mhm.
then they should.
They are
be
out
signed
of
again.
compliance, yeah.
Yeah.
But even if we say you're not in compliance until you obtain the permit, which is really the intent, that's what we've always intended. They can still game the system for another 6
Right.
months, and right, so they're not saying that the permit expired.
Right.
Technically, they were in compliance.
Right.
I don't know where.
So there's a difference with, if a case that comes in, they did the work and then it was double fines and they were supposed to apply for a permit. And then there are those cases where it's a driveway, they need a permit and we bring them to the board and the board tells them, okay, if you apply for a permit, you'll be good. So what they do is they apply for the permit, we consider that compliance and they fall off. They don't do anything with the driveway, they don't go ahead and do what they're supposed to do with the permit. So it's an issue and we have a lot of those cases open.
Well. We are on 6.2, right?
Correct.
And this is,
We went to the tangent.
no, I know, I followed that part. I just want to make sure I understand. They would pull it. Pay for a double permit fee, did they?
They paid for the double permit fee, but they didn't do the work.
Well, what are
Properly.
the pictures of this? Because the work had already been done.
Or they did the work before. So why was this
So
affidavit? We did?
that's why I'm,
But it
That
doesn't
way.
look like it needs.
just,
Like it
just
needed
figuring out.
work, they
So the
paid
work
two
is
fifty,
that they
affidavit of
pulled the permit
non-compliance.
And all they.
Okay, so
Luciano gave them a double fee,
They paid.
violation.
I remember what happened here.
Mhm.
So when we did this agenda, they hadn't paid. So they came in and they paid. This is a different type of case. Remember, I just said there are those that have already done the work with the double permits. So this is one of those. But we have cases coming up that the work wasn't done.
Okay.
So this one is in compliance.
This one's in compliance, they
Correct.
just have not paid the $250.
They did.
They did.
They paid they
Mhm.
did pay the fine.
And the double permit?
Yes,
Okay. All right, so this one's,
good.
we can close it.
We can close this one.
Okay, on case number CEN 24-697. I like to make a motion that there's compliance has been achieved and closed.
Second.
So there's no problem
All
on
in
the
favor?
permit.
The opposed,
You
motion
said that.
passed 5-0.
May I go back on this? I just read my own note. There's no progress on the permit. Here's what they did. There was applying for a permit is one thing, put in an application. They didn't go all the way. They didn't go to P&D because even though they've done the work, they still have to go
Right.
to P&D.
Back to that.
They have to go and have the work inspected. I'm so sorry. You have to pull that. So what we saw in the system was an application for a permit. However, the permit didn't go anywhere. They didn't submit the papers they were supposed to submit. And there was no inspections. They didn't go before P&D. So this is an open permit. Even though they paid the $250, they're still out of compliance.
And it's expired.
It's expired by now. It's 24. When did they apply?
So,
The 30th.
Yeah, there's nothing in the system on this permit.
before I rescind my motion, I just got a question. So basically for this case though, there is a violation, a fine. Is there anything stopping us from going back and reciting them because they haven't secured the permit?
That's one way we could do it. We still had this case open and on the agenda for intent to lien. Now they came in and paid the fine, which complied partially. However, they're still out of compliance because they didn't go all the way with the permit. They put in an application like we started out, but nothing was uploaded. The permit wasn't notarized. Paperwork that needs to be.
Unfortunately.
Yeah.
We can always put in a daily fine. So the deadline for a daily fine. See, when we first heard this, we did violation fine, we waived the admin fee, but we didn't do a daily.
So he's right, we can do it two ways. We can amend the order or we can reissue this violation.
We issue the violation, we've got to wait another month. I would.
We would have to give them
Set a
time.
deadline instead of daily fine. Kind of accomplishing the same thing without waiting another month.
Correct. And we'll reach out and explain to them what the board did.
What the
Because-
order.
Yes,
I'm on case number CEN -24-697, I would send my motion.
And I'll rescind my second.
Christine.
Like, if there were questions, I'd like to go ahead and make a motion.
And order.
In CEN 24-697, they are still not in compliance. Set a deadline of April 23rd for the permit to be obtained. If not, a daily fine of $250 per day.
I'll second.
All in favor? Aye. Any opposed? Motion passes 4-1.
4-1?
4-5-0. Thank you.
Next item is 6.3. It's for the property located at 10921 Northeast 10th Avenue. The case number is CEN 23-282 for Marie Rodrigue and her son Vito Pointville. We are bringing this case, but not intent to lien because the order didn't have
No fines.
fines on it. This is another case where they came in and said, oh, we're applying for the permit. And the board did not assess any fines because they did go ahead and apply for something. However, they haven't gone through with that permit. We have since filed an affidavit of non-compliance. This property is a non-homestead. And while the gentleman, Vito, came in the village and said he was going to apply for the permit and do what he needs to comply, we haven't seen any
But there
more.
are daily fines on this that should have commenced on September 19th.
This is another case where we assumed compliance because before September 19th, they applied for the permit. So this order needs to be amended to read, I think they need to pay some assessment fees and a violation fine because they implied that they have complied by applying for a permit when they didn't do anything with the permit.
We're gonna have to make that much clearer.
It has, yeah.
Sitting in front of your computer and inputting
Your name and address, and then the building clerk is asking you for a notarized affidavit, and none of that is uploaded. 2 years passed by and this case is just sitting there. And we are assuming, oh, they applied for a permit, there's a number, and they paid the fine, so the case is good in some cases.
This is almost 3 years old.
Correct. And considering that this is a non-homestead, I think the order of, we think that they should amend the order of enforcement and assess fines.
I do have one question. So they applied for it, but they had not, there is an administrative fine currently.
There was none.
It says, and an administrative fee
Oh.
will be assessed.
Will be assessed if, so what they did was they went in the system and got a number. Yes. I think what you should require compliance to be them going through with the process. We can give them extensions. They can ask for extensions on the order of enforcement, the compliance date on the order of enforcement, but we cannot tell them compliance is you applying for a permit. Because they'll come in, pay the 500, do the number, and then look like they complied and they didn't. When we went back through these permits, we found that these permits are just sitting there. They haven't gone through with any of them.
What can we do to correct it now, moving forward on this?
Is to amend the order of enforcement.
Is there any reason why we can't make it retroactive to the dates that are already in here, or would you prefer we set a new deadline with the fines and the deal?
It would be better to make a new deadline.
Yeah.
Yeah.
Like, let me ask the expert.
On case number CEN -23-282, I'd like to amend the order of enforcement. Start on March the 20th, 2024. Amended to find that a permit shall be pulled by April 23rd. If not, a daily fine of $250.
You just did what we've been doing. A permit shall be pulled by this time. So if we say that, he will go ahead and pull the permit and then won't go through with doing the work. You should ask for, yeah, you should ask for full compliance.
Well, all right. Wait a minute, obtain a permit by April 23rd. Or daily fine of $250 per day thereafter, and administrative cost of doing.
No violation fine?
Yes, violation has occurred. $250. Fine.
I'll second for discussion. Okay, so if I understood you, your motion is to amend the order of March 2024. Give the client state where they must have obtained a permit by April 23rd. If not, a violation fine of $250 and admin fee of $250. I'm sorry, you want the violation fine and admin fee. Even if they do comply by that date, or only if they don't.
I would say.
Can you add in the language for the permit to be issued? Because there's a difference between applying, pulling a permit and having it issued. There's a process that goes into issuing a permit. By the time it gets to, it's being issued, I'm happy to surrender the case to the building department because now they can monitor it.
That's a great analogy you use from now on.
Issued.
So, if I may, how long after they apply for it goes to P&Z would they realistically be able to secure a permit? If the first time, because I know a number of the driveways need a second hearing.
Correct. And we are happy to give them extensions of time and or bring them back here to ask for more time. However, you can issue orders for 60 days in situations like driveways, meaning they have to comply by such and such a date, which is 60 days from the date. So they have time to go to P&Z and they have time to go through with the permit process. They kind of work quicker when there is a deadline. Without a deadline, to get the permits, they just leave it alone. Yeah, they won't do it. So we have to have the word issued in there. So
Not an issue.
not pull, because they get a number and come to code and say, here, I got the number. I applied, but the permit has not been issued. No, applying is not issuing. There's a process, right?
Because usually by the next day after filming and signing, you know whether you can prove or not. That still doesn't mean you paid for it.
And that doesn't mean your permit has been issued.
Thank you.
So, well, I'd like to reset my previous motion, or amend the previous motion. On case number 16, that actually 282. That the violation has occurred, sets a fine of $250. Administrative costs of fee of $250. Direct the property owner to obtain and to have an issued permit by April the 23rd, or $250 per day fine there.
I'll second. All in favor?
Aye.
Any opposed? Motion passes 5-0.
That's good. Next item is 6.4 for the address 11345 Northeast 9th Court, case number CEN-23-341 for William Lomery. We were coming for an intent to lien on the $500 that remains unpaid for the driveway violation. This is a homestead. Mr. Lomery is requesting an extension on the order of enforcement on the comply by date because he's having surgery tonight. actually. 312. I did visit Mr. Lomery at his house, had a conversation with him. He came into the office and he did put it in writing requesting this extension. We recommend that the board grants it.
I don't see any daily fine, so he has complied.
He has complied. However, he hasn't paid the $500.
Right.
Did he install the driveway? Yes, Mr. Lomery installed his driveway.
We did
This
describe.
case came in front of us
Right.
4 times.
If,
You have to give another extremely, we were talking about being in comments, there could be something you don't know.
where is the?
But we're talking about established violation to occur. But I will, I guess whatever the board did.
Well, Jenny, I'm sort of in agreement with you also, in that, you know, it was already a set, finding. And the fees are already there, violation of the, costs, everything else, this is going back, almost a year, just short shy of a year, and, what I'd like to do is maybe give them, direct the village, I'd like to make a motion, if there are no questions. Case number CEN-23-341, direct the village to move forward with intent to lien, for $500, if the resident does not pay in full by April the 7th.
I'll second. All in favor?
Aye.
Any opposed? Motion has been declined.
Bless you.
But
Next item is 6.5 for the address 11460 Northeast 10th Avenue. Case number CEN-22-106 for Carlos Calozo and Lourdes Rosario. We are asking for a revised or amended order of enforcement. This is another violation for a driveway. Homestead property, they applied for a permit, but they haven't gone through with the permit. I called Mr. Carlos Colazo and spoke with him on March 6th. He stated that he was in Nicaragua working for the USAID and was unable to do the work. He, however, said he would be coming in Monday, which was last Monday, to start the work. I haven't heard from him.
But this daily fine should be approved, are they not? Because our last time he came in front of us, this was last time, April of last year, he was told that his daily fines would keep approving until the permit has been issued. So doesn't he have an ongoing daily? If he doesn't, why?
I believe this is another case where he applied for a permit. Let me see.
Oh, yeah, I thought that's what he said, yeah.
Where's that?
You already know that, not now.
I'm looking at the order of enforcement, it said there shall be full compliance with the stated provisions of the code ordinance and full permit by the 20th of February 2024.
I'm looking at an order of enforcement for the hearing that was held April 17, 2024, which says the daily fine will be stopped as ordered by in order of enforcement dated January 17th. Will be stopped once the necessary permits are pulled and paid.
Right.
Now, again, pulled and paid. He did pull the permit, but he didn't go all the way with it. He paid the $500, yes. So
The permit.
no, he didn't pay for the permit.
It's not compliance, the
Correct.
daily fine should have started.
He paid the violation fine and the assessed fee, the administrative fee. However, he went ahead and applied for the permit. He got a number. He sent it to us by email. Hey, look, I applied for the permit. Here's the number. However, we looked at this permit and there is no activity. Nothing has happened. It was on hold. The permit has been on hold for a while, almost a year. There's been no
So you pay
activity.
the violation and the admin fine, and what I'm not understanding is, well, that kind of looks like it's on us. Why wasn't the daily fine, why weren't the daily fines beginning to accrue as of his non-compliance date?
Because when you issue orders, you say if he pulls the permit at such and such a date and pays the fine, he's good. And this is why we are asking for the language to change a little bit and for compliance to, we should have an expectation of compliance for them to do the entire job. They should finish the job before we close these cases. Because if we just ask them to apply for the permit, they do that, and then building has several permits, open permits sitting there expiring and no work has been
In
done.
the system.
Right.
And it's a learning experience for us that will be better going forward. Because you need to, well, we already did get with the violation of the admin fee.
Mhm.
So what we need to do is change the daily.
The daily fine, amend the date for the daily fine, give him time, but if he doesn't comply by such and such a date, the daily fine would kick in.
I would.
He did, but he doesn't done the work.
April 23rd, to actually have a
See the
permit
picture.
issued, if not the $250 daily fine.
April 23.
But I don't know if I agree with you, that would be my motion.
Let's do that. Let's do it.
Said in the case of CEN CQ-106, we need to define the order of enforcement from April 17, 2024, to allow the property owner until April 23rd to have his permit issued, if not $250 daily fine.
Mhm.
All in favor? Aye. Any opposed? Motion passes 5-0.
Did we do this? No. Next case is 6.7 for the address 11636 Northeast 7th Avenue. Case number CEN 24-623 for PRBP LLC in care of the registered agent Rodon Law LLC. We're asking for an intent to lien for $250 that remains unpaid. They were found to be in violation of section 18.6 construction dumpster. They had a construction dumpster on the front yard of the property without first obtaining a dumpster permit. There is no permit in the system, and this property is a non-homestead.
There's still no permit.
No permit.
Now, okay, here's where I'm confused. If you go back to the order from September, it says affirm that the violation has occurred and has come to compliance.
By removing the dumpster?
Yeah,
but he still needs. One second, let me make sure I know what I'm saying. Yes, he did go and get the permit. However, he hasn't paid the $250.
Okay.
So it's, so the order's right.
The order is right. This one is right. This is a good one. We just need him to pay the $250, so we're asking for an intent to lien.
No questions. I'd like to make a motion, case number CEN-24-623. Directing the village to move forward with filing an intent to lien for $250 plus the applicable filing fees.
All in favor? Aye. Any opposed? Motion passes 5-0.
Has this one paid? No. He paid the administrator, but the dailies.
Okay. Next item is 6.8. The address is 11905 Northeast 12th Court. Case number is CEN-23-340 for Nicole Jean Jack and his wife Jean Jack. I. Smith Jean Jacks. Asking for an intent to lien on daily fines that run for a few days. How many days? So in this particular violation, it was for a driveway. They got the permits.
They got the permit, but they never did anything.
So here's another case where they did come in, apply for the permits, but they haven't obtained the permit.
They got the
They
permit.
came in and paid the 500, the 250. They paid that. However, this violation had a daily fine run from May 2nd of 24 to May 20 of 24, the date they applied for the permit. So there's $4,500 outstanding. However, they applied for the permit and didn't do anything with it.
Because the last communication from the city, I believe, is May 21st of last year, with once again, multiple documents missing.
Yes.
Okay.
And his daughter did come into the office to try and correct the problem, to find out from us what she needed to do. So we went through the process. She needs to go ahead and apply for the permit. Did she apply? She hasn't. We gave her the information,
When
but
did she come in?
last
Monday.
week, Monday. But if we have on the record, DSW 2434, which is the driveway permit. As you can see, there is no activity. They, when
And
it,
it's expired now,
correct,
so the village can go back and reissue a citation.
we can reissue a citation. However, we're asking for an intent to lien on the 4,500
Yeah,
that's
just want to make
outstanding.
sure that
Absolutely, we can.
if there are no questions, like, number CDN -23-340, direct the village to move forward following the intent to lien for $4,500 plus the applicable fine.
A second. All in favor? Any opposed? Motion passes 5-0.
Did we do that one? No. Next item is 7.3. For the address, 7.3 and 7.4, it's for the address 860 and 862 Northeast 120th Street, case number CEN -24-701, and case number CEN 24-702 for Catherine Brownell. These violations are for driveways. They were found to be in violation of chapter 5.6.1 off-street parking. Both driveways for the duplex, so on one side, the 60 and the 61 are both non-compliant. However, this is the case, if you recall, where we had the lady, the property owner missing, reported missing. At this point, the police department has sort of ended their investigation because everything looks fine. Her driver's license is up to date. It looks like there's been activity. Her bills are paid and everything is okay. They checked the morgues. She's alive somewhere. They still haven't seen her, but everything looks fine per PD. With that said, we will ask the board to go ahead and issue orders of enforcement on both cases. Because it looks like she's there somewhere. Maybe she doesn't want to be found. We wouldn't want to put that on the record, but
I'm just gonna ask a question and it's already answered. There's a picture from March 6th.
the property is cut, bills are paid, electricity is paid, water is paid,
And the property is fine.
right?
On somebody's side.
Is there parking in the back? Is there like a service road in the back of the property, like parking in the back?
I don't believe so, no.
There's no parking at all, some of those places they have them.
Oh, no, not this property, no, they don't have parking in the back.
They just park in the back.
Well, they have, yeah, two little rows that, they don't have driveways, they have two,
There's nothing visible on this.
yeah.
I don't even see that in the pictures, I just see a couple of walkways.
Yeah.
I didn't see any parking.
The properties are vacant, both of them. But we don't know if Catherine has properties other places, and she may be forwarding her mail to the other properties.
Is it a homestead property?
Once, it's homesteaded on one side. The other side was rented out. She lived in 860, 862 was rented out at some point.
But they're vacant.
Both of them are vacant. No one's living
Both
there.
are vacant now?
Correct. PD went out there and they didn't breach, but they looked through the windows and they said it doesn't look like anyone is living in the house. But someone is taking care of it and paying the bills, so. We would like the board to issue orders of enforcement.
One on case number CBN-24-701. And that's 4-002. That violation has occurred. Assess a fine of $250 for each case. Administrative costs of $250 for each case. And give the property owner until April the 23rd to have an issued permit on each case. If not, a $200 per day fine.
Second, all in favor?
Aye.
Any opposed? Motion passes 5-0.
Next item is 7.5, and it's for the address 1008 Northeast 114th Street, case number CEC 25-0149. The property owner is 748 DEV 4 LLC in care of the registered agent Formento George. We are asking for an order of enforcement. This property owner was found to be in violation of section 18.4.1, permitted days and hours of construction work. They were pressure washing at 7:25, creating loud construction noise. This is 2S.
If you look at 18.4.1, pressure washers making noisy, but they don't qualify. At 18.4.1 reads, the erection including excavation, demolition, alteration, or repair of any building or or delivery of materials other than at the following times is prohibited. We know pressure washers are allowed, but what are you constructing with them? When you do the noise ordinance, have they signed them under the noise ordinance, wouldn't count because that's 11-7.
Correct.
7:30 would have been fine. But I'm just not saying it's construction and that's just that.
Is this a construction site? See the pictures. The picture was a picture. Yes, we issued this violation based on what PD gave us. However, I'm not excusing that we didn't read the ordinance. We should have. This property is under construction. And
But according to the officer, what he saw, pressure washer, it doesn't mention construction work.
well, if you read the report on statute description, he says construction noise violation.
Because that's the code was used, whoever will not be using, but it says. Mr. Montoya Souza was observed operating a pressure washer. I'm doing construction work.
So using, it could be, and I respectfully understand where the board is coming from. However, a construction site having any type of equipment that makes enough noise, and of course, they didn't have a decimal machine to measure the amount of noise. If it was creating enough noise to disturb the neighbor, they are definitely in violation. However, I get it, the ordinance, it doesn't talk about construction noise in that way.
It's not, think about this, what about a homeowner who's pressure washing their driveway?
At 7:25?
It's not construction.
It's not.
The noise ordinance
Says they can, until, yeah.
So if we're gonna find.
Construction
in this situation,
sites.
we have to find every homeowner who might do the same thing.
Wouldn't,
You know, are we-
the manager would like to say something. No? No.
So under Miami-Dade County, especially very small farm board. Yeah, who license all the contractors within Dade County. To contract as a pressure washer, you need a license from the construction trades qualifying board. And it falls under the paint category. So it is, I would say it is considered some, especially construction type work. It's not, it's not your general contractor, it's not your subcontractor, but you need a license from the construction trades qualifying board to, go out and contract for that type of work.
But if I'm pressure washing my driveway, and in order to avoid, and I've done that, so I really do pressure wash my driveway.
At 7 a.m.
And I do it probably about 7:30 to start ahead of the sun. Am I gonna be cited, which I have to be then if we're gonna cite this?
You would be cited for the noise ordinance, I would think.
No, it's the noise ordinance here starts at much later at night, actually.
11 p.m.
11 to 7 a.m.
11 to 7 a.m. So it's, if she's pressure washing at 7:30, we technically wouldn't violate her. However, if it was the police, they would, because they go by Miami-Dade County ordinances.
Right, and I think the same question is, if you're out painting your house
Right.
at 7 a.m., would that be considered construction work?
Construction work, no.
I would say yes, that's.
Not by our ordinance.
But you need, it falls under the county code. And believe me, you need a license to do that type of work. But if you're doing it as a homeowner, no, you don't need a license, but it's still considered,
Construction work.
construction work, yes.
And we had this discussion at one of the commission meetings, like where do we draw the line between someone working, because the ordinance that in some part of it says they cannot start work a certain time. The reason why they can't start work a certain time is they create noise with their equipment.
Right.
So it's probably how the ordinance is written, but the reason why we cite them for doing work at that time is because they create construction noise, which is disturbing to the neighbors.
We had cases with Powell, Miami Beach, and where we had the same thing, where you couldn't start construction, where they would get there. The workers would get there at 7 a.m., right? And then we had a fence around the property, and they would open the fence and go on the property, and they were saying, hey, we didn't starting work, we just.
Sitting here.
And we said, no, you're at the job site, you're considered construction worker, any work that you're doing prior to that.
Correct. It would be the same as turning on, what do you call this thing where they get power? The generator. If they turned on a generator, it may not be listed in there as creating noise, but it is very noisy. And at a construction site, we have.
Here's the thing. They're cited under 18.4.
Yes.
18.4 does not talk about noise. It talks about alterations, et cetera, et cetera. If I'm running a generator because my power's gone on, you're gonna tell me I can't run my generator or 8 o'clock in the morning? We're getting real away from what this ordinance says. If the ordinance needs to be amended.
Yes.
To include these things because our concern is noise, rightfully so. Then that needs to happen, but when I'm looking at, they're not cited under Dade County Code. We cited them under our code of 18.4, which does not appear to include pressure washers.
Well, we could amend it if that's what you're seeking.
We can amend the violation.
To say that any work that's being performed under which a license falls under this construction trades qualifying board might be account.
And operating a pressure washer on a construction site is construction work.
Again, the ordinance would have to say any work done on a construction site.
I agree with that.
Versus what we have now, which is fairly specific.
Yeah, the code can be very vague, and sometimes we do struggle to finding which code to use with what, but she's right, maybe the code should be clarified.
I'm not comfortable.
When we in
finding the violation.
interpreting ordinances and statutes.
Yes.
There's it can be rendered,
There are gray lines.
void, for vagueness.
Mm.
It's vague, that it can be void, but it doesn't give you a reasonable,
Explanation.
opportunity to know what it is that you should or shouldn't be doing.
Yeah.
So I think that, when listening to what Sanders is saying, and, it seems quite, vague, particularly when you look at the language and look at what the violation is here. Under our code.
My only question would be, is this a construction site where it's, fenced in?
Yes, there is a construction fence.
Construction fence
Mhm.
around the whole property,
Mhm.
so it's a construction site.
It's a construction site. So they were working before hours, which is a violation. However, because the police officer mentioned the noise, I get it when she says that we have to be very specific. We shouldn't emphasize the noise part. We should emphasize the part that he was working at 7:25 when he shouldn't have been.
Right, I was gonna say, to me, it's a construction site.
And he's
It's a
pressure
fence
washing,
in.
he's
It's
working.
different than having somebody, construction going on. to replace
Correct.
The windows.
Yes,
Um,
agree.
But he got violated for running the noise, right?
Well, the ordinance that we used, 18.1, says that 18.4.1 says permitted days and hours of construction. So this one is specific to doing work on a construction site at the wrong hours of the wrong day.
And a fenced in property like this, that's deemed a construction site. to
Correct.
me,
If they are working at 7:25, they are in violation of this ordinance.
But then, and again, it defines what that work is considered. It just doesn't say, in general, work on a construction site. It defines the work, and I'm not seeing it, but anyway. That's it. If there's no more,
What is it?
the erection, including excavation, demolition, alteration, or repair of any building or delivery of materials other than at the following times is prohibited. It doesn't just say a general any work or construction.
Right, and it was specific work. It was specific work. None of that specific work, I don't think can really fall within the definition of what you're trying to accomplish with it.
Correct. I understand, but and then the danger with us, with the ordinance not being specific is there'll be someone on a on a construction site tomorrow painting, and then they'll say, hey, I'm allowed to paint at 7:25.
Yeah, but that's altering, because now you're changing the color. So that can go under.
And painting is just an example. It could be anything else that's.
When you pressure wash your driveway, you altered your driveway?
But you could be pressure washing the house, which.
Which is about to be painted,
I
yeah.
just see it as it's a construction site that is fully encapsulated with a fence.
Yeah.
And
This is
I mean, if you
construction
have
work.
somebody who goes on the property before 7:30 and they're just sitting there with getting everything ready and all, and they shouldn't be, it's still making noise.
They're working.
I'm not working, I am just pulling all my equipment out, it happens to be heavy and it's banging around. Making some loud noise, they haven't started, but they're at the construction site, is that not deemed work?
Not the way the ordinance reads. Anyway, okay, if there are no more questions, I would love to have a motion.
Okay, it's number CEC -25-0149. Find that a violation has, moved it. Like to make a motion that we find that a violation has occurred, assess the fine of $250, administrative costs of $250.
I'll second
All in favor?
Aye.
Aye. All opposed?
No.
Motion's, Rudolph, I'm sorry, I didn't hear. Yes, okay, motion passes 3-2.
3-2 or 3-2? Next item. This one is 7.6 for the address 10831 Northeast 10th Avenue. Case number CEC -24-0120 for Maria Laura Laos. Miss Maria was supposed to, their husband was supposed to attend, Mr. Lazaro Torres. They gave us his name and said he would be attending, but he's not here. They were found to be in violation of chapter 5.6.1 off-street parking. Their existing parking surface does not meet the village driveway design standards. They haven't paid the permit fees for the driveway. However, they were approved by P&D on Monday. So their permit is under building review. They just need to pay the permit fee. In this case, since they are showing progress, maybe we can give them more time. We can ask for a continuance again for 30 days.
Bring back at April's meeting.
Sure.
I'll make a motion in case CEC -24-0120 to table the case and bring back in April's meeting.
I'll second.
All in favor? Aye. Any opposed? Motion passes 5-0.
We did this one. So the next item is 7.8. It's for the address 11311 Northeast 8th Avenue. Case number CEC 25-0080 for Vanessa Hotstein Salami. We're asking for an order of enforcement with a violation fine of $1,000. This property owner and short-term rental vacation owner was found to be in violation of Chapter 19 short-term vacation rentals, unnecessary and excessive noise at a licensed property. They had tenants that were very noisy. They had a loud party. There was, I believe, a police report in, right,
And
submitted into evidence.
this is the first one.
This is the first occurrence. They did have violations before that have fallen off. So within this year, this is the first occurrence.
And there are no questions that I think about the case of CEC -0 and the violation has occurred, assessed fine of $1,000.
I'll second. All in favor? Aye. Any opposed? Motion passes 5-0.
Those were all the cases we brought before the board today, and I would like to mention that I will bring the chairperson's concern with how vague the code is to the village manager. And there, village manager and village attorney. There are some things, he has written a few codes for big cities, so we have to look at our entire code. And there will be some things that we will need to sharpen up. So some codes are very vague. I really appreciate that you brought it up.
To the well into construction.
Correct. Yeah. The vagueness, right. Yeah, if they appeal that case, they could use that argument to say, and I'm not giving them this, no.
Right. Did everybody get a chance to read February?
Yes.
Any changes, alterations, and, you know, make a motion to approve the February 2025 minutes? All in favor? Aye. Any opposed? No. Motion passes 5-0.
Who second? Who said,
Any other
who said,
discussion?
who was the second for the minutes?
Dale.
Dave.
Okay, I'm gonna say something. Mr. Garland.
As the manager? He's sitting right there. No. Not. He said no. He's the manager.
How many of these were I have to say?
Told him I come to me. I have two iPads.
This one.
Yes, I think that's fair.
Okay, and I'll motion to adjourn. All in favor?
Aye.
Thanks, everybody.
Thank you.
Yeah.
Yes.
You gonna recycle?
We do not recycle.
No more? Just shred them, yeah.